Good morning, Your Honors.
Good morning.
My name is Carmen Ware. I believe this is the first time I've been before this Court of Appeals.
Glad to have you here.
Thank you. I represent the appellant plaintiff, Ms. Keetly Marc, in this matter. Concerning this matter, Your Honors, there's really not much in dispute.
Counsel, do you want to reserve any time for rebuttal?
Do I have 15 minutes?
You have 15 minutes total. You can
Okay.
reserve some portion of that.
I'll reserve 3 minutes.
3 minutes, that'll be fine. Thank you. I'm sorry, go ahead.
Yeah. There's really not much in dispute in terms of this motion for summary judgment on the issues of fact. It is not in dispute that the defendant or appellee, Dr. Eck, performed surgery at the wrong level of Mrs. Marc's spine. It is not in dispute that several, in fact, 8 emails were sent in the course and scope of representation in a workers' compensation claim in which I represented the appellant, Mrs. Marc. 8 emails, all with attachments, were sent on November the 10th. I did not get to review those emails. Well, the particular email containing information later deemed relevant in this matter pertaining to a potential medical malpractice issue until November the 30th. Prior to that time, there was no issue concerning any medical malpractice. The representation of Mrs. Marc centered solely and was limited to the workers' compensation claim and what benefits she was entitled to under the Workers' Compensation Act. So we don't dispute that the items were received on November the 30th, November the 10th. They were timely reviewed, as timely as possible under the situation and given the prioritization of the workers' comp issues. So those items were reviewed on November the 30th. Mrs. Marc was informed on about December the 1st of information within the medical records from Southeastern Spine, which was the employer of Dr. Eck, information that tended to indicate that perhaps Dr. Eck had done surgery at the wrong level. And that is significant in that I understand that the trial court imputed that knowledge to Mrs. Marc that was received by me, her counsel. However, the information that it is our position that should have been imputed, if any, because the information was outside of the scope of the representation. But I think it's important to note that prior to becoming an attorney, I practiced as a critical care nurse for 20 years. So it was within that specialized knowledge that I was able to review the records and take notice that maybe something was not what it was supposed to be. But even then, that was a perhaps, because there could have been other situations where the surgery was done correctly at the L2 and 3 levels as opposed to the consented L3 to 4. And particularly, I think I may have made a note in here that there was some concern that maybe she had a sacralization of her spine, which is where the spine, levels of the spine become fused together, so it throws off the count when you're actually counting the spinal levels. That turned out not to be a consideration, and it is without dispute that Dr. Eck performed surgery at the wrong level. The issues in this matter are whether or not the discovery rule and the due diligence assessment have, for lack of better words, become divorced. And since we've been hearing a divorce all morning long, I'll stick with that theme. For decades, the discovery rule and the due diligence assessment have been happily married. You consider due diligence assessment when you're looking at the issue of the discovery. What was the date of discovery? In this matter, in this case, we would state that the date of reasonable discovery through her due diligence, and I would point out to the court what's already in the record, is that Mrs. Marc continued to treat, let me back up, Dr. Eck left town. Miss Marc came back in after surgery having problems with her spine. She had ongoing and increased pain in her spine, in her back. She saw a nurse practitioner on an emergent basis who ordered an MRI. The MRI was done that day, and an appointment was scheduled for Mrs. Marc to follow up with Dr. Eck, which she followed up with Dr. Eck. I believe it was, the surgery was done on the 2nd. She saw the nurse practitioner on the 13th. And, no, excuse me, she followed up with Dr. Eck on the 13th. Dr. Eck noted in the medical record that an MRI had been done, but he did not document the results of the MRI, nor did he explain to Mrs. Marc what the results of the MRI showed. So the MRI itself showed that there was surgical fluid at level L2 and 3, and there was evidence of a hemilaminectomy at L2 and 3. So those records, that MRI is what is allegedly should have placed my client on notice that surgery had been done at the wrong level. I say to you, I don't know whether that puts you on notice that surgery was done at L2 and 3 instead of L3 and 4. And I think what's the keynote here is that Mrs. Marc has given an affidavit. That would not have placed her on notice. She was not placed on notice of the potential for the surgery being done at the wrong level until I brought it to her attention.
Counsel, let me, before you, time goes by fast when you're up here, so before you run out of time, the trial court found when, what was the starting point for when your client reasonably should have discovered the date, possibility of the
date that I received the 8 emails with 8 attachments containing voluminous records.
Right.
Yes.
Is there any proof in the record as to how extensive the medical records were?
Other than the finding that they were voluminous records.
The trial court made a finding that they were voluminous?
I do believe that that language is used.
Okay. All right. Why is the trial court wrong in that determination? Because that's the issue that we're really here on. Why is the trial court wrong that the date that you received the medical records is the date the discovery time starts? And counsel for the appellee will go over this, I'm sure, but in Robinson versus, was it Baptist Memorial, I believe it was, the appellate court had found that in that situation, under those circumstances, the date of receipt of medical records that had been held for 3 years prior to being reviewed showed a lack of due diligence. And they noted that it is the date of receipt of records that starts the stops the tolling of the clock in terms of the discovery rule. And under those circumstances, I do agree that 3 years sitting on records, particularly in the context of a medical malpractice suit, showed a lack of due diligence. However, those records were received within the context, again, of a workers' comp claim. In addition, there was only about a little over a week maybe that had passed in which I had the burden of reviewing all of those records. I think to say, as soon as you receive records, you ought to review the exact record that you have no knowledge of or existence of. If you don't, if you perhaps reviewing something else and then get to this, then too bad for you. And I don't believe that that's what the law was meant to do. I think this case is more like, I'm going to say Green versus Sachs, where in that case, the court issued a finding that given the complex nature of the medical treatment that was at issue in that medical malpractice claim, that it would not have been reasonable to assume that without knowledge or explanation from someone with specialized knowledge, that a reasonable plaintiff or patient would understand that malpractice had occurred. So it wasn't until the patient was sat down and explained by other third-party care providers at Vanderbilt that she was the victim of medical malpractice. So I say that this case is just like that, in that Ms. Keetly, Marc, would have never known that she had a potential problem had not someone with a nursing background in critical care told her that. I'm not Mrs. Marc's nurse. I was hired as her attorney in the workers' comp case, so it's our position that what knowledge would have been imputed to her was outside of her understanding. And so it was within the role of a nurse that I was able to explain to her that perhaps something was amiss. And the record shows that Ms. Marc did everything she could. She went to all appointments. She went to consults, saw several other different healthcare providers, none of which told her that she had anything going on. She treated with Dr. Jolly, who was Dr. X's boss, after Dr. X left about 2 weeks after that MRI was taken. And Dr. Jolly himself testified under deposition that, you know, even though he'd been reviewing those records and looking at those X-rays, MRIs, he himself didn't become aware that surgery was performed at the wrong level until his deposition some years later.
Okay.
So,
Counsel, you've used your time.
thank you.
You have your time for rebuttal. We'll hear from the appellee.
May it please the court. As Ms. Ware has indicated, this is an appeal of a dismissal on summary judgment based on the expiration of the statute of limitations, and the primary consideration is the tolling of the statute of limitations and the application of the discovery rule and the constructive or inquiry notice standard. I think before I get into the facts, I would just like to review some of the public policy considerations which underlie the statute of limitations, because I think it's important when it comes to considering the specific legal issues in this appeal. As this panel is no doubt aware, the statute of limitations exists to promote stability, give notice to defendants of potential claims, prevent undue delay by claimants, avoid the uncertainties and burdens of stale claims, and to ensure the availability of evidence. And in order to support this public policy goal, the discovery rule does impose a due diligence standard on claimants when it comes to investigation of potential claims. And so in this case and in many other cases, consideration turns on when these claimants receive the information that alerts them to the possibility that they may have a cause of action. This is referred to as inquiry notice. And as soon as you gain possession of information, which is sufficient to place you on notice of the need to investigate whether you have the claim, that is when the tolling period ends and the statute of limitations begins to run. Now, in cases like this one, where we're talking about documents.
Counsel, excuse me.
Yes.
You're saying the time starts when they reasonably should have just at least investigated whether or not they had a claim.
Yes. So
Not when they reasonably should have found out they had a claim.
Exactly, yes. So inquiry notice charges a claimant with all of the information that a completed investigation would have revealed to the claimant as soon as they gain possession or even access to the information that just alerts them of the possibility that they may have a claim and they may need to look into it. I've cited a bunch of precedent.
About them having knowledge that that was a possibility. If they're looking at a received record, they're looking at something else, workers' comp. Okay.
Sure.
So they know that the surgery was performed, but it's performed as a result of an injury of workers' comp. Nothing about the surgery itself. Okay. So they received the notice of that. Do they have an obligation then at that point to scrutinize those records to determine that the actual service that was rendered, medical service rendered, was faulty?
Yes, and I'll tell you why. So when we're considering whether someone is on inquiry notice, what we are considering is whether a reasonable person in possession of or with access to that information would have been alerted to the need to investigate the injury. It is an objective standard and not a subjective standard. And so one of the issues that the court below characterized as a wrinkle in the law was, well, does the scope of representation matter as far as the attorney receiving the information on behalf of the claimant? And we would posit that it doesn't matter. Because if you're considering, well, I was representing a claimant in workers' comp and I was only alert to those issues, and I suddenly got a record that just reviewing it alerted me and my client by implication to the possibility that we've got a wrong level surgery, then you are considering the subjective perspective of the attorney representing the patient in workers' comp. That is, subjectively, is this information relevant to our workers' comp claim? When instead, we should be considering an objective standard. And this objective standard does not only matter when it comes to the scope of representation. It is the same objective standard that courts have repeatedly applied in reported decisions to date the running of the statute of limitations from the date of receipt of information and not review. And this is because—
Does it matter?
I'm sorry?
I keep interrupting you, so I'll just
No,
give
of
a
course.
general apology. Does it matter the amount of medical records?
It doesn't.
5 pages or 50,000 pages?
It doesn't, Your Honor, and I'll refer you to the reported decision of Daffron versus Memorial Healthcare.
Yeah, I'm familiar with Daffron.
Yes, of course, our firm is defense counsel there too, but, and of course, Ms. Daffron made that same argument. Well, these were thousands of pages of medical records. I needed more time to review them. And this court expressly rejected that position, that I should be given a reasonable amount of time to go through these voluminous records. And that holding by this court was based on the objective versus subjective Burke versus RHA Sullivan analysis. That is, if you have possession or even access, and the reason I keep saying access is because we don't just date inquiry notice from the date somebody gets a disc or gets an email with lots of records. I mean, in the other cases, it has been applied to claimants who have access to public court files or other information that they could go out and get. But in this case, we are talking about having records in the possession of the attorney. And in Daffron, this court said that we are not going to go along with Ms. Daffron's position that I needed a reasonable time to review the records because that would render the statute of limitations hollow.
Daffron wasn't it kind of mostly focused on her waiting till she got an expert opinion?
Yes,
And
that
we
was
said-
that was the
that
argument
was-
made, but the holding was nonetheless that the date that she received the records was the date when the statute of limitations began to run. And the pertinent portion of the opinion, considering this very issue, expressly rejected her position that she needed more time to review the thousands of pages of medical records. Now, this is not the only case where we're talking about receipt of information versus review. I would refer this court to Lane Detman versus Miller and Martin, where an attorney received a report of a background check which revealed that a separate attorney had not adequately performed one, and that led to a legal malpractice claim. And in Lane Detman versus Miller and Martin, the court said, no, it is receipt of the information by your attorney that begins the running of statute of limitations. It was not the date the attorney actually reviewed the report or the date the attorney later conveyed the information to the client, which, just as in this case, was only a few weeks later. And of course, you know, there's been arguments made about Keetly Marc's lack of medical training or sophistication. And, you know, I think that it is important for this court to remember that we're talking about an objective standard. And also,
not an objective standard of a medical personnel.
right,
reviewing a
and
record.
I mean, and I just want to call this court's attention to the
And
fact
you're
that we
saying-
are not just talking about an MRI report.
Counsel, wait a
Sorry,
second.
I'm so sorry.
When I start, you stop. Are you saying that a reasonable person, non-medical personnel, reviewing these records would have been put on notice?
Yes, Your Honor. And I do want to call the court's attention to the fact that we are not just talking about an MRI report. The trial court referenced 3 separate records, which all stated that the surgery at issue had been performed at L2, L3, and that is the entire claim, that the surgery was performed at L2, L3, and not L3, L4. And for this court's information, I will read the September 9, 2019 visit note, which says, "We'll ask Dr. Jolly to review case. It appears that the planned and documented surgery was for L3, L4, but on the updated lumbar spine MRI, the post-surgical hemilaminectomy defect is at right L2, L3. Our position of this court would be any layperson who has a claim based on the fact that their surgery was performed at L2, L3 and not L3, L4, looking at that record, should have been placed on inquiry notice about the issue with the level.
Did your client ever tell her that?
No, there's no evidence in the record that my client told her that, but that's not required. I don't think that...
I'm not understand you're saying. I'm just curious if it was so obvious that a layperson would be put on notice. I would have thought that the surgeon who performed it or the other medical personnel would have realized it and might have felt some obligation to tell the patient. Apparently they didn't.
There is no evidence in the record of that, Your Honor. And I think that the facts show that by the time the MRI is performed, August 13,
Now,
2019.
we're talking about that earlier report. Remember, you just said that's the one we look at.
I'm sorry?
Nobody thought to tell the patient that, gee, looks like the surgery was performed someplace other than where we told you it was going to be.
I mean, by that same token, Your Honor, the facts in the record are that my client was not aware of the issue with the level of the surgery until after he departed the group. So I don't think that there's any issue of concealment. And certainly
He did the surgery. The medical record was there. What was the record you ran?
So the surgery actually happens in August of 2019.
What was the record you read from?
Okay, that's September of 2019.
Not the date. What was the record?
Okay, so the first record is an MRI report, and
No,
that's...
I want the one you read from.
Oh, okay, that's September of 2019.
Not the date. Was it an operative report?
No.
What was it?
That is a later office visit note authored by a different provider. My client was never aware of the issue with the level until after he left the group.
How did he know?
He didn't.
The later provider. How did the...
Because an MRI was performed after surgery that showed the issue with the level, and then that later provider reviewed
Okay,
it.
so he looked at the MRI and then did this office note.
Yes, this
Okay.
provider is Rebecca Payne, nurse practitioner. My client departed the group, and then NP Payne took over plaintiff's care, and it was then that the issue with the level was first discovered. So
And nobody with the group told the patient.
I mean, so I think if you look at that note, it's pretty obvious, but I
It was
don't know.
so obvious, but nobody with the group told the patient.
I don't have the group, Your Honor, I only have the physician.
Is there anything in the record showing that anybody with the group told the patient, looks like maybe the surgery was performed in the wrong place?
Yes, that
I
happens.
understand that's not necessarily the issue here.
Yeah, that
But
that
my question
happens
to
several
you
months.
is there anything in the record showing that these people, the group, told their patient that the surgery may have been performed in the wrong place?
Yes, Your Honor. The plaintiff has put in that proof that Rebecca Payne later sat down with her and went over the MRI and showed her
was
the
that?
issue. That was in February of 2020.
Yeah, how long after she wrote the note?
5 months.
Okay.
So
This note was to Dr. Jolly.
this is a part of Ms. Marc's office records. So she is making a note about her plan to have Dr. Jolly review the case and about the issue with the level. So at this point, I want to make sure that we're covering the receipt and not review issue. I think that all of the available jurisprudence shows that when you receive information and not when you review it is what starts the running of the statute of limitations, assuming that is the information that alerts you to the possibility of your claim. I think the evidence is undisputed that it is these records that alerted the plaintiff and her attorney to the possibility of her claim. Plaintiff submitted not one, but 2 affidavits under oath in both her workers' compensation claim and this claim that it was just review of these records, not meeting with this nurse practitioner later, not having somebody else review the records, nothing that she needed to alert her to the possibility of her claim. And these are her own admissions under oath in the record. There are also multiple statements in pleadings, including the amended complaint, which state this, and these are admissions which are imputed to the pleader. And so I do want to touch upon the scope of representation issue. I think that once again, we're talking about an objective and not a subjective standard. And so if we really are considering, well, what was I thinking about what these records might reveal at the time I received them, as far as their relevance to my workers' compensation claim, or whether there was any suspicion of wrongdoing at the time of their receipt. We are, in fact, applying a subjective standard and not an objective standard. And ultimately, the same would be true of every single claimant who is claiming that the statute of limitations is told due to the discovery rule. In order to make that claim at all, you have to say that there was a point in time when you did not know of the possibility of your cause of action and you could not have reasonably discovered it. And so if the standard is, well, I had no idea, I had no suspicion of an issue with the level of my procedure, then at that point we are departing from decades of precedent on this issue, because this is a common refrain in all the jurisprudence: I had no idea. And even when claimants get the information, they then come back and say, well, I didn't know that this was actually malpractice. And Ms. Marc is saying that here too. I didn't know whether this was actually a sacralized issue or an issue at the level.
Counsel, let me, out of your brief, they have a duty to investigate and discover pertinent facts, quote, through the exercise of reasonable care and due diligence. So they get 50,000 pages of medical records.
Okay.
I used to defend docs. That's not uncommon, and I'm sure you're aware of that. I have no idea what it is in this case. What is this exercise of reasonable care and due diligence?
So it's twofold.
How does that play? If it starts as soon as you receive the receipt of the records, where does the exercise of reasonable care and due diligence come in?
Are you asking me about the hypothetical or the facts of this case?
Well, in facts of this case, when did the exercise of reasonable care and due diligence?
So it is our position that the statute of limitations begins to run upon receipt of the records.
I understand that.
Which were reviewed within a few weeks and obviously revealed immediately to both the plaintiff and her attorney that there might be an issue with the level of the surgery. So at this point, this is very similar to several cases that I have cited, including...
What is there to place you on notice that there's a problem medically related to medical malpractice?
I mean, again, I read that office note into the record, and I think it would be our position that the MRI, which reported the level of the post-surgical changes, and also the office note stating the planned and documented surgery was for L3, L4, but the post-surgical MRI shows it at L2, L3.
That was 5 months later, you say, though?
That would be, I mean, so no, that is an office visit note in September of 2019. That record was in plaintiff's attorney's possession on November 10,
It
20.
didn't matter how quickly it was reasonably, whether or not the exercise, I'm asking you now, and I know your time's up, I'm still like, reasonable care and due diligence. Under your position, and I understand your position, particularly with Daffron, under the exercise of reasonable care and due diligence, that doesn't matter. Here is, your position is when they get the records, it starts.
Yes.
Forget whether or not they exercise reasonable care and due diligence in reviewing the records. If they let the records sit for 2 years, or if they get immediately on them, it doesn't matter. So what do we do with this exercise of reasonable care and due diligence standard?
So I think the way the cases consider this in terms of the exercise of due care and diligence is you can't sit on records that you have and not review them.
It doesn't matter.
I'm sorry?
In your position, it doesn't matter. It starts from the time you get them. You can start reviewing them the day you get them.
Yes, because the exercise of reasonable care and diligence is an objective standard, and that objective standard has been applied in multiple cases to
How
say.
can you apply? My question to you is, if the time starts when they receive the medical records, what does this phrase, exercise of reasonable care and due diligence, mean?
I think
Doesn't matter. If they get on it the next day, too late, it started on the day you received them. So how do you fit in the requirement of exercise of reasonable care and due diligence?
Well, I think that the exercise of reasonable care and due diligence is a standard that requires that a plaintiff is charged with notice of what an entire investigation would have revealed, including the review of the pertinent medical records to that investigation. And I think in Robinson and Daffron and multiple other cases, they've said part of this investigatory inquiry notice standard is you have imputed knowledge at the moment you have this information in your possession. That's what inquiry notice means. So
I'm still trying to, I understand you made the position very clear, and I understand the position, but where does this exercise of, what is the exercise of reasonable care and due diligence? If it doesn't matter, you get the records, the time starts then.
Yes.
You're charged with knowledge then.
But you have no knowledge that something is amiss.
But that's why we have inquiry notice. I think part of the exercise of reasonable care and diligence is the inquiry notice standard. I think where we're talking past each other, Your Honor, is that you're asking me what reasonable care and diligence means.
Yes.
And I think that when the cases talk about reasonable care and diligence, they talk about that in terms of what a claimant needs to do. But when we apply the reasonable care and diligence standard, what we are applying is the inquiry notice standard. That is, that by definition, in order to exercise reasonable diligence, you are deemed to have notice of everything that your investigation would have revealed at the moment you gain possession of the information that alerts you to the possibility of the claim.
Okay, I'm just trying to figure out what they could or couldn't do that would exercise reasonable care. If the time starts when you get the records, no matter what you do before then, I'm just having a little difficulty figuring out where the requirement of exercising reasonable care and due diligence comes in. And one other question I'm going to ask you with, probably I'm gone far beyond what you anticipated here. You mentioned earlier that it's not just the receipt, when they have access
Yes.
to the information. Patient always has access to her medical records. Do you agree with that?
I have, and as someone who often responds to HIPAA requests on behalf of medical providers, I'll tell you that there's a specific process they have to go to get them, and there are delays built into that process under the applicable regulations. And so this is why we're always talking in these cases, in Robinson and Daffron and everywhere, about when did you get the records?
So it's not really access to them, because the patient does have access. There may be steps they have to go through to get them, but patient has access to her own medical records.
Well, sure. I mean, the reason that I was talking about access is because we do have a line of cases on legal malpractice where the court said, well, you didn't have these particular pleadings that alerted you to your attorney's legal malpractice on your desk, but you could have asked the court for those records. Our position would be that with respect to medical records, it's a different process than it would be collecting public court records. But I mean, I think the way that the reasonable diligence and inquiry notice standard has been applied, it's when your attorney gets the records, whether on disk or in an email, that your inquiry notice starts. And so in order to show that you are exercising reasonable care and diligence, then at that moment, you are charged with the notice of what's in those records. And then you have a year to review them and do whatever you need to do.
Okay, thank you.
Thank you.
We'll hear from the appellant in rebuttal.
Your Honor, just to answer some questions that may have been miscommunicated or answers that may have been misstated. In the exercise of due diligence after the discovery of the information, this pertinent information on November the 30th of 2020, several things were done to follow up regarding that information. Calls were placed to Dr. Jolly, calls were placed to the appellee, Dr. Eck, as well. Dr. Eck refused to answer any questions pertaining to this matter, treatment issues pertaining to this matter. The first opportunity that Mrs. Marc had to follow up with anybody where they would speak with her was doing a visit with the nurse practitioner, and it was not February of 2020. It was February of 2021 that she had an opportunity to speak with the nurse practitioner. And she was the one that brought up the issue about the surgical levels to the nurse practitioner. That information was not volunteered to her, but point blankly asked of the nurse practitioner, who did sit down with Mrs. Marc, showed her the x-rays, pulled out the film, showed it to her, explained to her what the different levels was, where her surgery was supposed to have been done, and where the surgery was actually done. And so that was the basis of our position, that it was at that point that she had knowledge that injury had occurred and that Dr. Eck was the person that performed the injury, that was responsible for the injury. So in closing, what I want to reiterate is this case is much like Green, where you have specialized knowledge that a patient is not likely to know without intervention from someone with specialized knowledge.
But Daffron at least says, I think, that a potential plaintiff, a patient, can't wait until an expert looks at the records and tells them that something is wrong. I mean, do you agree that that's what Daffron holds?
I agree with that, but I think what is like this case, what makes this case similar to Green is that you're looking at a surgery, as Green said, that was done, a medical device was placed at the wrong level. It was in the stomach. It was something that the patient was unable to see, and it was a condition that she was unable to observe. So until someone who reviewed those records, those MRI tests and testing, looked at that and then explained to her what was going on, that was the only thing that would have put her on notice. And then with Luna.
When was the MRI done? you both have told us, but I forget.
The MRI was done about a week after the surgery because she was having problems. The nurse practitioner who later told her about the problems was the one that ordered it. The MRI was available to Dr. Eck during the next visit, but he made note that the MRI had been done, but he did not document the results, nor did he tell Mrs. Marc what the results of that test was. So
You didn't argue, you didn't raise below at the trial court an issue of whether or not this was fraudulently concealed from your patient for 5 months?
I did, Your Honor, and the court said that there was enough evidence to prove because Dr. X said
You
that.
did raise it?
I did.
Okay.
And I wanted to state in closing that the standard that the information, the court ruled in this manner because no reasonable trier of fact could determine otherwise or decide otherwise. I don't think that burden was met because the court itself on 2 other occasions, on the motion to dismiss and on the motion for summary judgment, there were 2 hearings on the motion for summary judgment. The judge first ruled that Mrs. Marc had met due diligence and that the statute was told. He ruled that way on the motion to dismiss. For some reason, he called back later and said that we needed to have a rehearing. And on the rehearing, the 3rd and final hearing, he decided that the cases that were presented as far as Robinson, Daffron, and all of this indicated that it's the day you receive it, and he really had no leeway to decide otherwise.
Okay.
Thank you.
Thanks to counsel for both sides. We appreciate your argument this morning and your